For admission, I got one.
Lordship, I am appearing on behalf of TJ Monto. Lordship, on last occasion, registry has submitted one report, Lordship, dated 25/7/2024, as per the direction of the Honorable Court, dated 31st of May 2024.
Yes.
But from that report, Lordship, was we have seen, Lordship, altogether 20 cases are pending before its Honorable Court against some order passed by the trial court, Lordship. That criminal appeal 1, criminal revision 2, and criminal petition 17 is pending before its Honorable Court. But from this report, Lordship, what we have seen, Lordship, that report is not exhaustive against what are the nature of those cases is pending before the court below, and against which order this criminal revision has been filed, Lordship. From the compilation has given by the registry, we have seen that only 9 cases against which the criminal petition has been filed can be found, Lordship. But other cases, the nature of cases, offense, what offense, in which cause it is pending, it is not found, Lordship, from the report, Lordship. So one comprehensive report may be directed to furnish that name of the MP MLA, court which is pending, what is the status of
Where
cases.
is the report you are referring to? Where is
Report
Mr.
dated
Mahanta? Where is Mr. Mahanta?
25/7/24, Lordship.
Where is Mr. Mahanta?
He is on leg, Lordship, in another division bench, Lordship. That report dated 25/7/24, Lordship.
So there is a list of 20 cases.
20 cases, Lordship.
These are all pending before the High Court,
High Court, Lordship.
principal seat and outlying benches.
Lordship.
What has happened to these cases?
Lordship.
So who is representing the registry here?
Lordship, TJ Monto is representing, Lordship.
But you are complaining against the report of the registry?
No, I'm not complaining. I'm suggesting, Lordship, that a comprehensive report may be directed because that report is on 25/7.
No. But what has happened? Have these cases been listed?
Lordship, some cases has been listed on 1/8/2024, Lordship. So the latest report is required to be listed, furnished, Lordship. That I am submitting.
We have had enough of this report business. These cases are to be listed before a special bench.
Special bench, Lordship.
And what about the outlying, the district judiciary, cases pending in the district
Yes.
judiciary?
In the highest numbers of cases, Lordship, in district judiciary is Kamrup. Total 33 numbers of cases is pending. All are, Lordship, out of that, Lordship, 1 land grabbing case, and 5 is session tribal case, 10 GR case, 13 CR case, and 1 special NIA case, and 3 special CBI case, Lordship. And that special NIA case That is at the stage of charge framing, perhaps that charge has been framed, Lordship, against one MLA, Lordship.
All right, from the respondent side, anybody wants to respond?
Report, madam, only them. The report that was directed by the last order, madam.
Report is there already.
The copy we haven't got.
Take down, Mr. P.P. Datta, learned counsel has appeared on behalf of Mr. T.J. Mohanto, who is reportedly busy in another court. Mr. B.D. Goswami, learned additional AG, State of Arunachal Pradesh submits that, as well as, you have received the report, the other, Miss, as well as the comma so-and-so, Mr. B.D. Goswami, learned additional AG, State of Arunachal Pradesh, Miss P. Bhattacharya, learned additional AG, State of Mizoram, and Miss M. Kechi. You are additional AG or a government advocate? Additional AG, State of Nagaland, have submitted that they are yet to receive the copy of the report dated 25/7/2024, submitted by the Registrar General. Full stop. From a perusal of the report dated 25/7/2024, it appears that as many as 20 petitions, 20 criminal petitions stroke criminal revision petitions involving MPs and MLAs are pending before the principal seat of this High Court. Full stop. The report further discloses that these matters have been listed from time to time. Full stop. However, there is no material to indicate as to the progress made therein. Full stop. Insofar as the district judiciary is concerned, the report mentions about the number of pending cases against MPs and MLAs pending before the courts below, which are in different stages. However, from the said report, it is not possible to ascertain as to the time that will be necessary to, it is not possible to ascertain as to the progress that have been made in these matters since the filing of the report. Full stop. In view of the above and taking note of the overall facts and circumstances of the case, we issue the following directions. Number one, copy of the report dated 25/7/2024 be furnished to the learned advocate generals, additional advocate generals of the states of Arunachal Pradesh, Mizoram, and Nagaland within a week from today, so as to enable them to come up with their response. Full stop. Insofar as the 20 criminal petitions, stroke criminal revision petitions pending before the High Court is concerned, the registry may take necessary steps for listing all those cases before a special bench after obtaining before a special bench, preferably within 10 days from today, after obtaining necessary approval of the Honorable Chief Justice in the administrative side. Full stop. Continue, Gorgo. Once these matters, full stop. Once these matters are listed, it would be expected that the special bench so constituted for the purpose will take all steps for expeditious disposal of these cases. Stop. Number three, insofar as the cases pending before the district judiciary is concerned, an updated report indicating the stages in which these petitions were pending and the progress made in respect thereof since the filing of the report dated 25/7/2024 be brought on record. Let this matter be listed again on 25th of January 2025, subject to availability of the bench. Full stop.
God bless you.
Availability of the bench at Guwahati.
It's okay. No, fine, no problem. It's okay.
Yes.
The state of Assam has filed an affidavit, my lord, Saturday evening, my lord. I'll have to take instructions on that, my lord, because although your lordship is directed to file it beforehand, but it was filed on Saturday evening, so I have got it, my lord. I'll take the instruction. So far as Arunachal is concerned, my lord, the registrar, he has physically visited all the courts and he has filed a parawise reply to the affidavit filed by the Arunachal on the last occasion. That your lordship is there in the record, perhaps. It is dated 29 November 2024. I think, my lord, my learned brother, Mr. Goswami, has to take instructions on this because
No, just a minute,
I'm sorry, my lord. I'm
You are
sorry.
saying the state of Assam has filed an affidavit.
Yes, my lord.
When?
Saturday evening, my lord.
Can you give
Seven.
the date,
I'm
please?
sorry, I'm sorry. I'm sorry. my lord. 7, my lord.
What does the affidavit say?
Uh, it, uh, it has given, my lord,
Where is the affidavit?
previously your lordship passed the order because the last affidavit or last instruction that was placed before your lordship was pertaining to the month April and March 2024.
Now with
The lordship-
updated information, we have filed this affidavit in respect of all the 35 districts.
Yes, yes.
So you need time to examine this.
Yes, my lord.
All right. What else next? Which state?
Arunachal. Arunachal, my lord.
Arunachal. What is the issue? Arunachal?
Arunachal,
Your lordship, I think last order was 25. That is on record, you know. However, we have to, keep updated. Make us. So far as, some small issues like somebody being saving, residential buildings and all that. Possibly on that.
Mr. Goswami, would you please come this side? Use the microphone, please. What is what is the status of new High Court building?
That is, my lord, progressing smoothly, man. We have given the dates,
Yes.
everything, my lord.
Date ko?
My lord, that your lordship had seen already. Your lordship will kindly come to the order dated. Last order, my lord, 4/11/2024. My lord, second page of the, third page of the order, your lordship had, may I read out, my lord? From the above, we are satisfied that every effort is being made to complete the building at the earliest so as to enable the stakeholders to avail the facility. Mr. B.D. Goswami, learned additional AG owner, has assured that this court, that under the guidance of the core committee and with the active cooperation of the state of Arunachal Pradesh, all necessary steps are being taken to ensure timely completion of the new High Court decision, no further order. But we have asked for updated status, but this parawise comment, my lord, has come.
Okay,
possibly, that has to be, I will take on instruction.
No, but when will the building be ready for inauguration?
July, August, my lord. Progressing, work is progressing.
So you want to file an affidavit?
Yes, we'll file an affidavit. On this parawise comment, that is not here on the record, that is possibly sent directly here. That copy we have to be.
Parawise comment of?
Lord, the registrar has inspected all the subordinate judiciary,
Hmm.
and he has filed a report in the form of a parawise comments to the earlier affidavit filed by the Arunachal.
If a copy be given to.
I'll give him a copy, my lord. Yes, I'll furnish him a
What is
copy.
the date of the report?
29 November 2024.
Where is that report? Is it there on the report?
Has to be there. my lord. I not didn't give. Huh?
Main file? Let us see. These reports and affidavits, you keep it in a separate file.
এই তো report, তোমার একটা copy দিয়ে দেওয়া। কেইটামান সৰু সৰু বস্তু আছে। এইকেইটা আপনি update করবো লাগবো, pursue করবো লাগবো। এইটো।
Thank you.
So you want to examine that?
Yes,
report
ma'am.
And respond.
Ma'am.
Then you bring your response by an affidavit,
Affidavit, ma'am.
also indicating the expected date of completion of the
High
new
Court.
High Court building,
My lord.
indicating the tentative schedule when it will be ready for inauguration.
Yes, my lord.
All right?
My lord.
Okay, and then Nagaland, the advocate.
Please, madam.
Yes,
My lord, pursuant to the last directions,
yes, yes.
the Honorable Law Minister has sent a communication to the Finance Minister
Mhm,
requesting that as far as Nagaland is concerned,
mhm.
in terms of the Honorable Governor's views also, the construction would require special assistance to states for capital investment. So
Yes.
detailed report, communication has been sent to the Honorable Finance Minister, which is under consideration before them. Pursuant to that, a communication was issued to the Honorable Chief Minister in November, and on 26 November 2024, the Honorable Chief Minister has also responded to that. Those communications are being placed on record now. The last time there was some confusion because the Law Department had filed an affidavit denying
Yes.
all these facts. Then your lordship said, under what conditions they are taking a view different from what I had stated. That was the question last time, there was confusion on that. They were to.
There's too much noise this side and little noise this side. We are unable to. Could you repeat, Mr. Balgopal?
On the last occasion,
Hmm.
I think the central government through law ministry, I think, had filed an affidavit in this honorable court, which was not on record. But
Correct.
the gist of it was conveyed to your lordships,
Yes.
as though that nothing has happened from their side. Maybe
Mhm.
they were not aware of what the honorable law minister had said, because he had a detailed meeting with the honorable chief minister and other ministers and also all the officials. And then made a detailed recommendation to the finance ministry, to the honorable finance minister itself,
Hmm.
incorporating the requirement of assistance even according to the views of the honorable governor. All these things are there in the communication. Now the matter is pending before the finance. And hopefully something will turn out from them, in which event, with the intervention of this honorable court, as has been happening in the last few occasions, something positive will turn out. We are just awaiting the decision of the finance department. A very strong recommendation has been given by the law minister. That clearly shows that he was present and he heard the grievances and he sincerely wanted to help the government out of this present position.
So what is the response of the finance ministry to this request?
Just awaiting that response, my lord. We are pursuing it further with the honorable law minister. Something tangible is expected because the requirement is such, and we have been given to understand that the response will be positive. So we are just waiting. That's why the honorable chief minister himself has written to the officers concerned that whatever is to be done, it will be implemented, it should be implemented in right earnestness. We're waiting for that. It was because of the directions given earlier by the court, we got this opportunity. And fortunately, the law minister had also come to the state of Nagaland. That's how I could place this before your lordships. Things are going on the right direction, I would say at last.
May I submit, Lordship, pursuant to the last order passed by your Lordship.
No, but first of all, what
Yes.
is happening? The departmental minister says something, your
No,
affidavit
No,
says something else?
Lordship, that is what I had taken up with the ministry, Lordship.
Yes.
I have got a letter from the ministry. It has been issued with the approval of the Honorable Minister, Lordship will see.
What does it say?
Lordship will take the first flag.
Mhm.
I'll give you. To make a submission. Lordship will come to the first flag.
Yes.
First is my letter wherein I had put in the submissions made by the learned advocate general.
Mm.
And I had stated that there was a contradiction between the affidavit file and the statements made by the learned advocate general in the court. Now,
Yes.
Lordship will come to paragraph 4 of that letter.
Yes.
The Honorable Minister also clearly reiterated the stand that there is no budgetary scheme program being administered by the Ministry of Law and Justice, which could accommodate the request of the state government, and therefore Ministry of Law and Justice is not in a position to help in terms of additional resource allocation to the state government on this account. The action taken by this department was further communicated to the Chief Minister so and so. So now
Mhm.
the stand that we have taken is that it has to be borne out of the consolidated fund of the state. Now your lordship will come to the letter issued by the Honorable Governor, that is at the second flag.
Mm. Yes.
That is dated 22nd August.
Mhm.
The governor makes a request.
Yes.
Pursuant to this, the letter dated 25 October 2024, which my senior has just read out. Lordship will come to paragraph 2 of the letter dated 25th October 24.
Yes. That
Where-
we have seen. This
Yes.
letter is there.
And the letter dated 5th November 24.
Yes. Mm. Yes.
Now, Lordship, a submission was made
Yes.
on the earlier occasion, Lordship, which I have made available in my letter, Lordship. The Honorable Minister had personally visited the new High Court building construction at Kohima, and after threadbare interaction with various authorities of the government of Nagaland, including the authority at the highest level, has assured the state that necessary arrangement for release of adequate funds will be made at the earliest so as to ensure completion of the construction of the new High Court building at Kohima without further delay. But that was not something which was committed by the governor, the honorable minister. Because there are funds for the different ministries. If at all the funds have to be made available, that has to be from the Ministry of Finance.
That's all right, Mr. Dilip Chaudhary. What we found was a little difficult to accept is, we understand these things have their own connotations, legal implications. But the fact remains that the Honorable Law Minister actually has, for whatever reason, for whatever be the reason, has taken some interest and is trying to resolve the issue.
No, that is,
And so therefore there is some positive step. When, how much, that is a matter.
that
time
is
will tell.
another aspect of
So
the
the
matter.
ministry, the law minister of the country is paying a personal visit, taking so much of interest, trying to resolve this problem. And the department is filing affidavit saying that we have nothing to do with this.
No,
Is it not a contradiction?
it is not.
You may
some-
have your problems in doing things in a particular manner. That's understandable. You may not have the fund. But to say that, sorry, this is none of our business,
It is,
then why is the minister, honorable minister looking into
that
it?
is the law minister, what my statement before this honorable court is, lordship, that the law minister has not given a commitment because he cannot. Here is a situation where the law minister has referred it to the finance ministry, who has to give the funds. Who has to give the funds? Law ministry.
Who is asking for a commitment?
No, that was what.
Courts don't function on commitments.
That
We
was what-
want to pass
that-
an order, we'll pass it.
That was what that was the kind of submission that was made on the last day. That
No.
has given an assurance that this will be done.
That's not correct. They're not happy with this stance of the department. See, the idea is to come together and find a solution.
Yes,
What
lordship,
is the stand of the law ministry? We don't, this is not our job, the high court is so and so. What kind of argument is this? From day one, this is the argument which has been advanced. Is the government of India not concerned about?
Lordship, the government of
The
India.
government can say that we are interested, but see, we don't have the budgetary provision. So we are trying to arrange.
No, now
That
that
is another thing. There is not even a whisper of that kind, even in the last letter.
Lordship,
Where is the last letter? Come, read it again. 29th of November. There is not a,
5th November.
no, the letter written by some director, Y. Kumar.
Yes,
This letter is after the visit inspection of the Honorable Law Minister.
yes, lordship.
If the Law Ministry had nothing to do, then why has the Law Minister gone to the site? What for? There has to be some
Lordship,
positive approach.
lordship.
We appreciate that. The Law Ministry, led by the Honorable Minister, has taken a positive stance to see what can be done.
Lordship.
Whether this can be done, that can be done, that's not the issue. here.
That is another aspect.
And consistently, the department director is saying, sorry, we have nothing to do with this. Please don't involve us in this matter. That is the tenor of this letter. There is no mention in this letter of 29/11 that the Honorable Law Minister had visited the site and we are trying to explore possibilities.
Lordship,
Nothing of that sort.
lordship, that letter has been enclosed in with this, the letter of the
No,
law
no,
minister.
we are asking you about this letter of 29th November 2024.
Yes, lordship. Here,
This is issued by some Yashashvi Kumar, director.
yes, lordship. And
Look at the tenor of the letter. There is not even a whisper about the visit of the Honorable Law Minister. Yes.
Lordship,
And on 25th, the Honorable Law Minister makes a request to the
yes,
Honorable Finance Minister to please help out.
yes, lordship.
And this is the stand of the director. You are expecting that we'll fall for this kind of stand. Where is the mention about all these things in this particular?
Lordship will come to paragraph 3.
Yes.
In response to the above DO letter dated so and so of the Honorable Governor, The Honorable Minister of State for Law and Justice, Independent Judge, copy is enclosed, wrote demi-official on 25/10/24 to the Honorable Finance Minister, requesting her to examine the demand of the Government of Nagaland suitably for additional funds for completing the construction of the new High Court complex at Kohima under the scheme for special assistance to states being administered by the Department of Expenditure under the Ministry of Finance. The Honorable Minister also clearly reiterated the stand that there is no budgetary scheme program being administered by the Ministry of Law and Justice which could accommodate the request of the state government, and therefore the Ministry
So,
of.
so are you saying that the law ministry has nothing to do in this matter? Will delete the name of the secretary and proceed with the matter?
No, Lordship, the Law Ministry has to, Lordship, be in touch with the Finance Ministry to get the funds released. It cannot on its own.
Where is your affidavit? You filed an affidavit.
Yes.
Where is it?
You filed it on the 411, Lordship.
Lord, we were not served with a copy of affidavit filed by. And
I'll give it to her,
documents
Lordship.
that is provided the lordship. All of those has been.
When was the affidavit filed?
411, Lordship. मीडिया के कहने का फाइल हो No, not right now.
No, Mr. Dev Chaudhary, you have to clarify one thing
Lordship,
right now.
Lordship.
You see, on last order. There was an order passed by this court
Lordship.
seeking the response of the law ministry, correct?
Lordship.
That order is
11/9.
11/9. Please see what is mentioned in that order.
Situated thus, this court is left with no option but to ask for the stand of the Department of Justice, Government of India, seeking its opinion as to whether there is any way out of the stalemate so as to facilitate early completion and inauguration of the new High Court building at Kohima.
Where is the response to this in the affidavit? That's, please point it out. Where is the opinion? Please point it out. What is the opinion of the, according to you, what is the opinion? What is the
Lordship,
response to
this-
that order?
This would be specifically to the Department of Justice.
Mhm.
The query raised by my lord is ask for the stand of the Department of Justice, Government of India.
Correct.
Department of Justice, Government of India does not have a scheme or the funds for the establishment of a high court.
So therefore, nothing can be done. Is that, why that line has not been
Huh?
added?
I would not say that, Lordship. Because the government functions collectively. Here is a case where the Ministry of Law and Justice has taken it up with the Ministry of Finance. Now, until and unless the funds come from the finance, the Ministry of Law and Justice cannot do.
Correct, you're right on that. We agree with
Yes.
you. This should have been stated. What is this man saying? The deponent,
No,
he's
this-
teaching the law to the court.
This lordship will come to the letter dated,
No, it's not on record. We'll not
no,
look into any.
it's not on record, but submitted by my learned friend and it's
No,
it
Mr. Dev Chaudhary, this has a significance, a bearing. Therefore, you will have to,
file an additional affidavit if you
you'll
lordship.
have to
would like.
clarify that.
I'll file an additional affidavit.
Because we are sitting here with some purpose.
Yes, yes.
All right, we are not going to take stray letters coming from a director. of
No,
department.
that was only
These
for
are
lordship
stray
perusal.
applications.
I'll bring it on record, lordship.
Where
whatever
is the
materials,
response
yeah.
of the court's query in this affidavit? There is no response. And it is being said that this is filed in terms of the order dated 11/9/2024.
That was specifically for the Ministry of Law. Therefore,
Specifically for it.
no option but to ask the stand of the Department of Justice, Government of India. So
So
Department of
is the deponent representing the Department of Justice?
Lordship,
Is he representing?
yes.
Then where is the stand? All kinds of things are happening. One way he doesn't respond, files affidavit, gives sermons to the court, and then is totally non-committal. On the other hand, we find that, as we mentioned, the law minister takes pain to personally visit this site. And as the learned advocate general has said, he has assured help. Assuring help doesn't mean committing.
Lordship, let it come on.
And he has
affidavit.
also, the
Let it-
honorable law minister has also taken steps.
Law Minister has
So
taken
efforts
steps.
are on to find a solution.
Yes,
And look at the affidavit filed by the departmental officer, telling the court that please
No, I
don't
will-
bother us.
I can file an additional affidavit bringing on record those particular letters which have been issued at a later date.
Mr. Dev Chaudhary, we have not taken this affidavit kindly. You can communicate to your client. We'll deal with it, and it could be really harsh. We don't appreciate this kind of conduct of bureaucrats. This is not the way. He is going tangent to even the stance of the departmental minister. Who has asked for a commitment? The order is that what is your opinion? The opinion appears to be positive. The head of the department, the concerned minister is taking positive stance.
It's not a commitment of the ministry, lordship. On the last occasion.
All right, then a judicial order will come. You want to file an affidavit?
I'll
If you
bring it
want
on-
to, then you file. Otherwise, we'll pass a judicial order on this.
I'll file an affidavit, lordship.
How much time do you want?
Let it be on reopening, lordship.
All right. We can give you a little more time if you want. But we are not happy with this kind of stance. This is not the way. As if he is telling the court that you look somewhere else, don't bother us.
It's-
We'll write a judgment, full-fledged judgment on this. Don't have any
Lordship.
doubts. Hmm.
I'll give it to her. It's,
Copy of the affidavit.
lordship.
All right. Okay, you take down, नाम भी लिखिबो, so and so. Stage ke das, amicus curiae. Miss Chaudhary, anything you want to add?
Your Honor, State of Assam has not served a copy on me, but then I had gone through the report and it seems that the standard design for toilets has been circulated to all the districts and they're adhering to that. And I'm told by the registry that a meeting is happening tomorrow and that they should be discussing the further details of that. It's indicated in their report as well, you know. Although a copy has not been served on me.
এখানে লিখে দিন অফিসার এপালে দিব মিস্টার ডি মজুমদার লানেট এডিশনাল এজি স্টেট অফ আসাম বাকি চাৰিজনৰ নাম ধরে মিস্টার আর কে ডি চৌধুৰী লানেট ডিএসজিৱাই ফর দি ইউনিয়ন অফ ইন্ডিয়া আৰু এইফালে মিস্টার এ ফুকন ফর জিএডি ইউ আর দেয়ার ফর জিএডি Ashraf for PNPO is also present. Full stop. Mr. Das submits that pursuant to the order dated 01/10/2024 passed by this court, the state of Assam has filed a detailed affidavit on 7/12/2024, bracket Saturday. However, due to late receipt of copy of the affidavit, he has not been able to examine these statements for making suitable response in the matter. Full stop. Ms. R.S. Chaudhary, learned amicus curiae, also submits that no copy of the affidavit has been served upon her till date as a result of which she is unable to make a response with regard to the steps taken by the state for construction of toilets across the state of Assam.
Yes, sir.
Toilets for
All districts in the entire report.
which category? For normal toilets or?
No, they have formulated a standard design for males, females, transgenders, and for Divyangs. And that is being considered by in all the districts.
Toilets for various categories of end users. Full stop. Uh, Mr. B.D. Goswami, learned additional AG, State of Arunachal Pradesh submits that the work of construction of the new High Court building is going on in full swing. And before the next date fixed, he would be in a position to indicate a tentative date of completion of the construction work for the purpose of finalizing a date of inauguration of the building. Full stop. Insofar as the report submitted by the Register of Itanagar Permanent Bench dated report stroke parawise comment dated 29/11/2024 pertaining to the status of ongoing construction work of judicial infrastructure in the state. Mr. Goswami submits that since no copy of the report has been served upon him, he is not in a position to respond to the same at this stage. Full stop. Insofar as state of Mizoram is concerned, there is no live issue to be looked into in this proceeding. Full stop. Coming to the next important issue, which has drawn the attention of this court, special attention of this court since last 2-3 occasions. That is completion of construction of the new High Court building in the state of Nagaland. Mr. Balgopal, the Advocate General of State of Nagaland, has addressed the court through RVC, remote video conference, and submits that the Honorable Law Minister has already made a request to the Honorable Finance Minister of Government of India on 25/10/2024, seeking special financial package for the completion of the construction of the High Court building, and a positive response in respect thereof is anticipated. Full stop. A copy of the letter dated 25/10/2024 has also been placed for perusal by this court. Full stop. After going through the letter, we find that some positive steps have already been initiated by the Ministry of Law and Justice by making request for finance before the Ministry of Finance. Under such circumstances, the request for adjourning this matter so as to await the response of the Finance Ministry appears to be reasonable. Full stop. Mr. R.K.D. Chaudhary, learned BSGI, submits that although the Director of Department of Justice had earlier filed an affidavit dated 4/11/2024 responding to the order dated 11/9/2024 passed by this court. Yet, in view of the subsequent developments and the specific queries made by this court today, he be granted 4 weeks time to file an additional affidavit clarifying the stand of the department by bringing the relevant documents on record. Full stop. After taking note of the submissions made by the parties and the requests coming from the different governments as noticed above, we deem it appropriate to adjourn this matter till. 30th of January,
My
2025.
As of now, my lord, may kindly accommodate me. We have the Assam Nagaland border dispute on 30th.
Acha, acha. The 25th. When is the other matter fixed? 25th is a Sunday, I believe, or Saturday.
25th Saturday.
Then we'll have it on 20th. It would 28.
28.
28, 28. Ago to 28 kore dibo. 28, 28. In the meantime, the respective affidavits be brought on record by serving advance copy. Respective affidavits stroke reports be brought on record by serving advance copy to all the interested parties.
Milord, one small submission, Milord.
Hmm.
Let this affidavit of the Union of India be filed through the Secretary Ministry of Law and Justice because department is represented by the Secretary normally.
Mr. Das, it is for them to decide who will swear the affidavit.
Because
Unless we have a reason, we are not.
it
saying-
appears that the director is
Let him first file,
excess
please.
of, it's an excess of bureaucracy, it appears, Milord, from the contradictions.
We'll say we may require the secretary.
If
Yes.
he says so, that letter has been issued with the approval of the honorable minister. I cannot do anything.
Let him try.
Item 3 and 4.
Much obliged.
Mr. Chaudhary, what are these?
My lord, this is regarding the fixed pay part. It would be covered by your lordship judgment.
Hmm.
In fact, in the earlier judgment, my lord, paragraph 166 to 179, lordship has dealt with this aspect.
Judgment has been reported.
No, I have got a copy, my lord. I see. It has been reported also.
So is it covered by the judgment?
There, when Lordship said, directed us to consider a pay scale, Lordship had taken into account the fact that teachers and tutors, well, they should have some equality in the service. But here, these are non-teaching staff totally. Non-teaching staff. These cases relate to the non-teaching staff. So the teacher-tutor comparison would not come in. My humble submission. That is one part of it. They had also challenged section 4, my lord, of the 2018 Act. These are two different acts actually we are talking about. One was a provincialization of the teaching staff and this is the provincialization of non-teaching staff. They're totally different chapters. So that analogy, if we try to draw here, there we had a teacher to see whether they should be getting a scale or not, but here there is nothing, my lord. That case, we had given them a simple fixed pay. Here, what we have given is the minimum wages. It will be as per the minimum wages. Every time it is revised, we are giving them the revision. So that part may be required to be addressed separately in my humble submission, matter. Otherwise, if lordship thinks fit,
My lord,
different issue.
rather, my lord, I'll just put it the other way around. Now, in the case of teacher and tutor, there's a question of qualification was involved. Here, that aspect is also not there. Now, your lordship's view is, if somebody is a government servant for all practical purpose, when it comes to pay, that was a larger issue which your lordships addressed. Whether a fixed pay concept can be made applicable. Your lordships took the view, no. Yes, if somebody is in the lower echelon, if somebody is having lesser qualification, he may get lesser pay scale. But there has to be a pay scale. There is no question of any fixed pay being given to a government servant. So that was a very larger issue which your lordship has decided. Now certainly, and there, my lord, the question was somebody having some qualification, that's why he's been made teacher. Somebody was having lesser education, therefore they were made tutor. That is not even there. It's a non-teaching stuff. So same schedule, my lord. There was slightly more. It was 12,400. Now it is 8,000, 9,000, something like this. In my humble submission, my lord, of course, they may argue that's a different issue, but I don't think there is any scope for any taking a different view in these batch of matters.
But that's all right. But the point is, since he has raised it,
Yes, yes.
it has
Let
to be
them-
heard.
They have a right to address. We are not saying no, my lord, but then we'll deal with it, my lord, if they come up with such an argument.
So these matters are ready as regards pleadings, ready for hearing, all cases.
Oh, affidavit, yeah, no.
In the lordship.
They have not
cases,
filed their
we'll file our
affidavit.
affidavit and they'll file their reply to it. So now the issue has become shorter. I'll file a short affidavit.
Any appeal preferred against this judgment to your?
No.
knowledge?
To my knowledge, no.
No.
Right, that's right,
Not yet.
Mr. Secretary.
We are not filing appeal, the other case. We are only filing a review application because of 2, 3 observations which may create some problem in future.
Which are those? Can you just indicate?
One is
The
that,
review is not there.
one observation of that, of the 2011 Act is also applicable. Some rights have been accrued on that also. So Lordship is giving equal status to 2017 Act vis-a-vis 2011 Act. The 11th Act was already set aside. So there cannot be any right accrued from that Act. That one line observation is very damaging, maybe for in our future cases. Otherwise, lot of cases will come, they will claim their rights on the basis of 2011 Act in one paragraph.
No, all right.
We have already drafted. It will be filed.
Perhaps those observations were made in the context of section 6 of this.
Yeah, that clarification will also may help us, but some clarification will be required. This way, that way.
What do you have to say on this?
On this case, we'll file the affidavit in the other case,
Hmm.
and Lordship may fix up the matter for final disposal maybe in the new year.
Obviously, it has to be in the new year. But will you be available in the new year?
Yes,
to argue the matter?
only from tomorrow till 19th, I am not available. 20th, I will be available. Then there is a vacation.
Let the affidavit be
Yes,
filed.
let us file that.
How much time is required?
2 weeks time will be sufficient for us.
All right. Mr. Kiran Chaudhary, learned senior counsel, listed by Mr. S. Bhattaku. And counsel has appeared for the petitioners in these 2 read petitions. Mr. D. Sakya, learned Advocate General Assam, assisted by Mr. R. Majumdar, and Standing Council Education Department, has appeared for the respondents and seeks 3 weeks' time to file counter affidavit in both these read petitions. Since the request is not opposed, same stands allowed. Let these matters be listed after the counter affidavits are filed or after 4 weeks, whichever is earlier.
Highly obliged.
Necessary orders.
Deep-
Listed for necessary orders. What is 5 and 6? 10. 5 and 6 also same. 5 and 6 are same. Actually, 3, 4.
Same, that's grade 4.
So we can pass a common order.
same.
4 and 5.
Common order.
3 to 6, same order. Common
Yes.
orders. All right. $11:45.
May I plead before Lordship? I plead before Lordship for listing a criminal IA which has also mentioned on last on 2 of this month and which is not listed today, my lord. For today, any date of this week, my lord.
When do you want it?
My lord. My lord. Thursday.
In case you listed today. Then you wait, we'll pass an order. in the main case.
Must be.
May I plead your lordship? I beg to mention for listing one criminal appeal lordship for Friday.
For what? Listing for what?
Criminal appeal lordship.
It will- once.
Orders,
Orders.
orders.
What order you want?
Lordship Friday.
Rejected. Yes.
For admission item 1.
May I please? Lordship, this is a statutory appeal against conviction under section 302 of IPCL.
So we'll admit it.
Not
Sir, R. H. Chaudhary.
Arrested.
Or you say R. H. Chaudhary in counsel for the appeal. His appeal is directed against the judgment and order dated Well, 21/12/2023 passed by the learned Sessions Judge, Karbi Anglong, in connection with Sessions Case number 44/2011, whereby 2011, convicting the sole appellant under Section 302 of the IPC and awarding him the sentence of life imprisonment and also to pay a fine of rupees 20,000 in default to suffer simple imprisonment for 6 months. First of all, we have perused the grounds taken in the appeals, admit the appeal, call for the LCR, issue notice returnable in 4 weeks. Since Ms. S. Jahan, learned APP Assam has appeared and accepted notice on behalf of the respondent number 1 stroke state, no formal notice is required to be sent to the said respondent. However, steps by registered post with AD for service of notice upon the respondent number 2 stroke informant.
Obliged.
Yes.
May it please your lordships, it is an appeal against conviction under section 302, my lord. Convicted, sentenced for life imprisonment.
And fine.
My lord.
Mr. S.
Fine, 20,000.
Other things will, there's the case number. Judgment and order dated 21/10/2024. Judgment dated 21/10/2024 and order dated 24/10/2024. Passed by the learned Sessions Judge Gwalpara in Sessions Case number 68 of 2017. What is the fine amount?
20,000.
20,000.
20,000 fine. And in default, 6 months.
6 months, simple imprisonment.
Simple imprisonment. The rest will be the same. Informant is a party here.
No, my lord.
Yes. Huh?
So,
Acha.
so then the respondent number 2 part is not required. There are 2 appellants,
No,
My lord.
each of the appellants.
Yes, ma'am.
So then there is 34 also.
34 is there.
Yes, yes.
302
302
of the
read
34 IPC.
Item 3.
Much obliged.
Also 302.
Yes.
302, my lord, life imprisonment.
149. Read with.
4 appellants.
4 acres.
4 appellants. Also 5-year imprisonment, my lord, under section 325.
Leacock heard Mr. S. Chauhan, counsel appearing for the appellants. This criminal appeal is directed against the judgment and order dated 18/11/2024, passed by the learned Sessions Judge, Hojal, Shankardev Nagar, in connection with Sessions Case number 146, bracket capital H, bracket close, oblique 2013, convicting the appellants under section 302, read with section 149 IPC, and sentencing each of them to undergo rigorous imprisonment for life and also to pay fine of rupees 25,000. In default, to undergo simple imprisonment for another 1 year. Full stop. Each of the appellants have also been convicted under section 325, read with 149 IPC, and sentenced to undergo 5 years of rigorous imprisonment and pay a fine of rupees 10,000 each, in default to suffer simple imprisonment for 6 months. Full stop. We have perused the grounds taken in the memorandum of appeal. Admit the appeal. Issue call for the records. Issue notice returnable in 6 weeks. Since Ms. S. Jahan, learned APP Assam, has appeared and accepted notice for respondent number 1 stroke state of Assam, no formal notice is required to be sent to the said respondent. Extra copies, na lage. Petition appellants to take steps for service of notice upon the respondent number 2 informant by registered. It takes steps.
My lord, I have instruction that my lord informant that is respondent number 2 expire, my lord. So police report may be called for.
To make it 4 weeks. In view of the submission made by Mr. Chauhan, a police report may also be called through the office of the learned public prosecutor Assam, indicating as to whether the respondent number 2 informant is still alive or not.
Lodge.
There is a IA also.
My lord, yes, after receipt of record, my lord.
So and so for the applicants, so and so for the state. This IA has been filed under section.
389. Oh, now,
Yes.
now, is it?
the side of
430.
BNSS.
430 of BNSS.
Have you mentioned it in your IA?
Yes.
My lord, yes.
BNSS?
415, my lord.
430 लिखी sir. 430 you have written?
Sorry.
430.
Seeking
430,
suspension of
yes.
jail sentence and also for release of the applicants on bail. The prayer made in the IA will be considered after receipt of LCR. The state may in the meantime file objection if so advised.
Lodge.
Hello, name of my senior may be good.
By Mr. B. Narjari, assisted by Mr. S. Shaw. Yes.
There are 4 accused persons, but 149 is dead. Perhaps others were not recognized.
Nineteen seven, 2023.
24,
24. It has not been listed till today.
my lord.
You are appearing for?
Informant. Informant, Lordship.
Informant.
Is fine.
Then we'll ask the IA to be listed along with this.
My lord.
Heard Mr.
Has there be a class?
SZB Aklas and counsel appearing for the appellant who submits that on 19/7/2024, a separate interlocutory application being IA criminal under serial number 6309/2024 has been filed in this case seeking suspension of jail sentence and release of the appellant on bail. First up, however, according to the appellant's counsel, the said IA has not been listed before this court till date. First up, Ms. A. Begum, learned APP Assam is present for the state, whereas Ms.
SG Borua.
S.G. Barua, learned legal aid counsel, is present for the informant stroke respondent number 2. On the request of Mr. Aklas, register to list this criminal appeal along with the connected interlocutory application. The state may file objection in the matter in the meantime, if not already done. List after 10 days, Codium.
Must.
After 10 years.
Hey, please, your lordship. I'm appearing on behalf of Mr. NNB Chaudhary. Who was
Mr.
NNB Chaudhary. He was appointed amicus curiae, but he is out of town. So I'm appearing in, on behalf of him.
So this matter is ready for hearing,
Lordship, paper book is prepared, Lordship.
Paper book is
admitted. And what about informant?
different party.
Which section is involved here?
302.
302, Lordship.
302, we can
We
proceed
can
for
proceed,
hearing.
Lordship, it's perfect.
Mr. So-and-so, your name, please?
A. Burman.
Mr. A. Burman, learned counsel has appeared and submits that Mr. NNB Chaudhary, learned amicus curiae, engaged in this case.
Lordship, may I make one submission?
Huh.
My senior had requested for listing in admission. This.
Okay.
Take your seat. Learned amicus curiae appearing engaged in this case is out of station. The learned counsel, however, submits that this appeal is ready for hearing. Full stop. Ms. A. Begum, learned APP Assam, has also supported this said submission. Stop. We find that the appeal has already been admitted and the paper book has been prepared and furnished to both the sides. Since the conviction in this case is under section 302 of the IPC, register to verify if there is any requirement for service of notice upon the informant, and if not, the matter be listed for hearing in due course.
Obliged.
Appeal, Lordship. Lordship, this is this application, my lord, for 389, my lord. Of the Code of Criminal Procedure, my lord. The praying for suspension of sentence, my lord. Upon the petition of my lord.
Yes.
The impugned judgment and order dated by 12/2024 and 17.
So conviction is under which section?
302, my lord. 302, 304B and 34.
302?
304B and 34, my lord.
How many applicants?
3 applicants, my lord.
302, 304B and 34. All right. All.
Charge sheet has been filed by my
Listen,
lord.
listen, all three of them have been convicted under
Lordship.
on this provision.
Lordship. And petitioner number 1, my lord, he is the husband of the victim, my lord, and petitioner number 2 and 3, my lord, parents-in-law. And in this matter, my lord, for the ready reference, my lord, I have prepared a compilation, my lord.
So what is the ground on which you are seeking bail?
In this matter, my lord, there is no any eyewitness, my lord. And although there is a oral witness, my lord, for dying declaration.
So
but
first of all, conviction is based on what?
on the basis of the statement of the PW 1, 6, 7, and 8. And they are the interested and relative of the victim, my lord. And objection already filed. And PW 10, my lord, the IO, they have no, the learned court below not consider the statement of the IO, my lord, on the record, and shows that the IO has not properly investigated the matter.
Okay. You can argue? Yes.
Lordship.
Don't argue the appeal. Argue for bail. You get
No.
only 10 minutes to argue for bail.
Lordship.
If you are not interested in 10 minutes, will not pass any bail order.
Lordship. I am
No, Mr. Mubarak, you
Lordship.
submit compilation, 10 compilations. In 10 minutes, if you don't get the order, you don't get it.
within 10
And
minutes,
I
my
am not
lord.
allowing more than 10 minutes.
Lordship, within 10 minutes, I'll complete, my lord.
So therefore, bail application, you should
Lordship.
know how to argue it.
Lordship.
Don't start from here, beginning FIR was lost, so and so, so and so. What is the main point for bail? Tell me.
Lordship.
Tell us.
Lordship, kindly say.
Already
Page-
3 minutes has gone.
Lordship, page number 8, my lord. On oath, the PW 1, my lord, is the father of the victim, my lord. In the third line, my lord, the occurrence took place on 28/7/2016, my lord. But the occurrence took place on 27/7/2016, my lord. And thereafter, Lordship, kindly see from the bottom, my lord, 7 line man, one Raj Ali, who is the co-villagers of the accused person, informed my co-villager Idris Ali. And on the relevant night, the occurrence that my daughter was suffering burn injury and she was laid on the banana leaves. After getting the information of Idris Ali, I accompanied by my 4 other co-villagers straight away to the GMC. But in the Lordship, kindly see in the cross-examination, page 9, my lord.
Yes.
Page 9, the Azhar was lost by me at Kaurbaha OP in the evening time. My thumb impression on the Azhar was obtained at Guwahati, my lord. At the time when I arrived at GMC and on the relevant night, my daughter was asking for water and she was lying on the latrine. Lordship, and kindly see the third paragraph, my lord. It was not a fact that my previous statement before police, I did not state the Amjad Ali, Shahar Ali, Faizul Ali, and Nur Jahan also accompanied me on the relevant night in GMC. Next, my lord, we did not find our daughter in a sound state of health.
These are not arguments for bail. Anything else you have?
Lordship.
What are you trying to say? You have to tell us a ground which raises a controversy which indicates that they may or may not be guilty. That's the point.
Lordship.
These are nothing to do with your bail application.
Lordship, kindly see
And
that.
5 minutes are already gone.
Lordship,
left to finance.
kindly see the deposition of EW 10, my lord.
What is your formulation? Can you tell us? What are you trying to say?
I stand to stand, there is no any eyewitness, my lord.
All right.
And although they have stated that the victim has stated that the petitioner number 1, 2, and 3, my lord, on the instruction of the petition number 2, that they pour kerosene upon the victim, my lord, and he sent him the fire, my lord. And on the date of occurrence, my lord, and although 4 and 5 are the neighbor, my lord, but they have examined the prosecution declared him the hostile witness, my lord. And
We'll engage a legal aid counsel for the applicants. He is not being able to tell us anything relevant. These kind of arguments, we will be compelled to dismiss the application, which we don't want to do, because others will suffer. He is not being able to give us anything.
Lordship,
This
let the
case-
matter be fixed for final hearing, Lordship, as the paper book is ready, Lordship. Paper book is ready, then let it be hard on land.
2024 matter, finally.
Lordship,
There are other cases also.
Lordship.
Mr. Mubarak, you are not prepared. You are not being, you don't have any idea how to argue a bail application. You are arguing all over.
Lordship.
Bail, what is the point for bail?
in this matter, my lord, the petitioner number 2 and 3, they are living separately, my lord.
On the request of Mr. Mubarak, Land
Lordship.
Council for the applicant, this matter is adjourned for a week. I'm prepared, otherwise we'll engage a
Lordship.
legal aid council.
Lordship.
This kind of arguments will not be accepted here.
Must be.
I can tell.
Lord, it is an appeal against conviction, my lord. We have filed an IA
IA is for,
suspension of sentence and release on bail.
right, conviction is under which section?
364A and 120B.
364A and 120B. Conviction is for how long?
Life imprisonment.
Let's see the IPC.
Objection filed. Lordship will have to file objection, Lordship, if we'll place the bail, Lordship, IA. For IA, we'll have to file an objection, Lordship.
You have to file objection.
Objection, Lordship, it is mandatory.
Lordship,
Lordship.
How much time you want?
Lordship, 3 weeks, Lordship, is because next week is only.
Second week of January.
Lordship,
Requested. Heard Mr. S. Dale and counsel for the applicant. Also heard Ms. E. Begum, Lanet, APP Assam, appearing for the state, who submits that 3 weeks time is required. Further 3 weeks time is required for filing objection on behalf of the state. Since the prayer is not opposed, same stands allowed. Registered to list the matter again in the second week of January 2025. In the meantime, objection, if any, on behalf of the state, be brought on record. Yes. By
Much
serving advance copy upon the applicant's counsel. Yes.
Much obliged.
I can 11.
Here, my lord, with all respect, my lord, objection has been filed and a compilation we have placed it before the learned public prosecutor.
So 389.
389, my lord. I'll be very cryptic, my lord. Primarily 4 witnesses, my lord. Primarily 4 witnesses, my lord. And all of them, my lord, implicate only out of 10 appellants, my lord. Only 1, my lord, he has been implicated, not the rest, my lord. And my lord, medical evidence, my
The
lord,
conviction is under
114 and 302, my lord. And 326, 149, 3 years, my lord.
and 302 life.
My lord. And my lord, the injured witness, my lord, he was examined, my lord. Date of occurrence, my lord, say today, my lord. He was examined 10 days thereafter, and doctor has opined, my lord, that the injuries were 24 hours prior hand, my lord. Meaning thereby, my lord, their lordship knows, my lord, there your lordship authority is also there, my lord. It cannot be the injury sustained in the fracas that occurred on the date of occurrence, my lord. There's a hiatus of 10 days, my lord. I'll be very practical, my lord. My lord, Lordship, my lord, it will take 1 minute, my lord, with all respect, my
This,
lord.
there are 10 applicants. 10 applicants.
10 appellants, my lord. One is named, my lord. We're praying for 9, my lord.
Yes.
My lord, with all respect, my lord. Lordship, may I have a look at the FIR that is at page 61, my lord.
Yes.
PW2 is the informant, my lord. May I just read it, my lord? Humble submission on 2006 in the morning at about 8 p.m. while we were harvesting black gram crops in our own land, the accused person named below, armed with deadly weapons like so and so, so and so, so and so, entered our land and attacked us. Accused number 1, he is appellant number 1, my lord, and 2, appellant number 2 here, my lord, hit my brother Mainal Haq with dagger on his chest and hands, causing his death on the spot. When Joinal Haq tried to resist them, accused Abjal, he is appellant number 5, my lord, assaulted him on the chest with a spear remaining in his hand, and the other accused persons caused grievous injury by assaulting on various parts of the body. 2 injuries only, my lord. And the accused persons also seized my brother Kasem Ali with an intention to kill him, but my said brother saved himself by running away. Later on, when the people of the village arrived, the accused persons fled away. This is the FIR, my lord. Thereafter, my lord, PW1 doctor, my lord, page 68, my lord. The story of the FIR is negated in the evidence, my lord. Page 68, my lord. My lord, the second paragraph, my lord, 1 penetrating injury found over lower chest. Thereafter, 2, my lord, 1 cut injury over palm aspect of left index finger, my lord. 2 injuries, my lord, 1 is fatal, my lord. With all respect, my lord. 10 appellants, my lord. Thereafter, my lord, with all respect, my lord, the first informant, my lord, he is PW2, my lord. In the FIR, he names 2 persons, my lord. Page 70, my lord. PW.
Where is the postmortem report?
Postmortem report is not there, my lord. The postmortem report is not. Doctor's evidence is there, my lord. Judgment also it is reflected, my lord.
The postmortem report, do you have a copy?
No, 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 we don't have a copy, my lord.
Have you received the LCR? See, why we are asking you, here the doctor mentions about injury number 1 and injury number 2.
My lord.
But we can see at least 4 injuries from his statements.
My lord. My lord.
1 penetrating injury found over chest.
My
This is
lord.
number 1.
My lord.
Then another, a probe could be passed in the abdominal cavity.
That is whole, my lord.
That's right. So 1 in the above the chest, 1 in the abdominal cavity.
No, 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 my lord. No.
It maintained like this.
Went from outside to inside, my lord.
So it's single.
Single injury. Continuous, my lord.
116 is a report of chop wound, medical report is there, Lordship. Page 116.
Hetu regarding the injured witness, my lord, not the dead one, my lord.
Medical report check.
Hetu injured.
Ah, ठीक है, 9.
I'm sorry.
9. Lordship, I'm sorry.
Yeah, my
Both of you are sorry, then.
no, no, no. I said, my lord, that injury report she is quoting, my lord, pertains to the 326 character, my lord.
Lordship, Lordship.
My lord, it's all respect, my lord.
No, Mr. Mahajan, please help us understand this doctor's witness.
My lord, my lord.
Testimony. He has mentioned that there is 1 penetrating injury found
Yes,
over
my lord.
lower chest
My lord.
on left side.
My lord.
Size 1.5 inch into 1 inch.
My lord.
He stops there.
My lord.
Then he says a probe could be passed
My lord.
in the abdominal cavity,
My lord.
directing from left to right side. So chest and abdominal cavity are two different things. Correct?
Different things.
So that means under serial number 1, we are looking at 2 injuries.
My lord.
Then number 2, you see 1 cut injury over palm on left index finger.
My
This
lord.
is 3rd injury. Then
My
he
lord.
says liver was found perforated. That
My
is
lord.
another injury. So at least 4 injuries are there as per the
My
testimony.
lord, may I read the cross, my lord? May I read the cross, my lord?
Yes.
Injury number 1 is found to be a fatal one, my lord.
Mm.
Rest are, my lord. The other injuries were not found to be fatal. Only 1 injury is found to be fatal, my lord.
No, but how a perforated liver is not found to be fatal? How
Perforation
an
is.
abdominal cavity directing from left to right side is not found fatal?
Yes, my lord.
How
My lord,
a lower chest incision of 1 inch, 1.5 inch into 1 inch is not found? So which there are at least 3 injuries which are obviously fatal.
if that is taken into account, also is very correct, my lord. Even in that event, my lord, the ocular evidence, my lord, my lord, even if the say, my lord, medical injuries, my lord, 10 appellants, my lord, nothing is attributed to anyone, my lord. Ocular evidence, 7 except 1 appellant, my lord. Appellant number 1.
3. Appellant number 1, 2, and 5.
Not in the evidence, my lord. In the FIR character, my lord, he stated one thing in the FIR, but in his evidence, my lord, PW2, my lord, he is the first informant, my lord. He implicates only 1 appellant, my lord. Can I read it,
Yes,
my lord?
please.
With all respect, my lord. With all respect, my lord. PW2, my lord, that occurs at page 70. He happens to be the first informant, my lord. May I just read it, my lord?
Yes.
With all respect, my lord. I am the complainant of this case. Exhibit 2 is the Ajaha. Exhibit 2-1 is my signature. I know the accused persons. The deceased Mainul Haq is my cousin. The occurrence took place at about 7-8 a.m. on 2006. On the date of occurrence, I, along with the deceased and my other brothers, went to our land to the harvest crop, black gram. At that moment, the accused persons armed with lathi, phala came to our land and attacked us. Accordingly, Abdul Hai, he is appellant number 1, my lord. In FIR, he names 2, my lord. All of a sudden assaulted my brother Moinul Haq. When I tried to prevent them, the accused persons came towards me and attacked me, and then I went away. The incident of Marpit lasted for about 8-10 minutes. My another brother, Joynal, resided to the north of the place of occurrence at a little distance, and the same persons also attacked him. My brother sustained cut injury on his chest and he died on the spot. He doesn't name 2 here, my lord, only appellant number 1, my lord. Abdul Hai, my lord. This is PW2, my lord. I am come to PW3, my lord. And my lord, in the cross occurrence took place, my lord. Page 72, my lord.
Yes.
1 paragraph only, my lord, down below 5 lines, my lord. There were cultivation of the corpse belonging to Abdul Hai. My lord, 1, 2, 3, 4, 5, 6, 7th line from down below, my lord. I begin, my lord. There were may I read, my lord?
Yes, please.
There were cultivators of crops belonging to Abdul Hai and others near the place of occurrence. There were black gram cultivation and other crops. The accused persons came to the place of occurrence field and stated that the black gram cultivated by them and black grams belonged to accused persons and asked us not to harvest the same. Then there was altercation for about 10-15 minutes. This is the bone of contention, my lord. And thereafter, my lord, PW3 exactly same, my lord. He doesn't name anybody, my lord. PW3, my lord, and that occurs at page 74, my lord. He names only 1, my lord. Page 74, my lord. With all respect, my lord.
Yes.
I know the complainant and the accused persons. I know that this is Moinul Haq, so and so. The occurrence took place, goes on and on, my lord. At that time, a group of persons armed with lathi, phala, deadly weapons came from the eastern side of our land and entered into our land and asked us why we were reaping harvest on black gram in a shade land. Then we replied that it was our land, we planted the crops. Then one of the persons in the group exhorted others to attack. Then one of them assaulted Moinal with lathi and accused Abdul Hai, appellant number 1, my lord, inflicted dagger blow on the left side of the chest of Moinal, the deceased, my lord. When Joinal came up to Moinal, all the accused persons started assaulting him with lathi, phala in their hands, my lord. The injured is also a witness, my lord. He happens to be PW9. I'll read that, my lord. Thereafter, my lord. PW9, my lord. Page 95, my lord. The rest were not eyewitnesses, my lord, in cross. That is why I have not read them, my lord. Now, PW9, that occurs at page 95, my lord, who happened to be the injured witness, my lord. Even his presence is doubtful, my lord. That I'll come later, my lord. May I read, my lord? May I read, my lord?
Yes, please.
I know the informant and the accused persons. It has been 12 years since the incident. I did cultivation of black gram crops on my own land. At around 7-8 p.m. on the day of incident, I was harvesting the black gram crops. The accused persons came to my land and started assaulting Moinal Haq, the deceased, my lord. Moinal Haq was also harvesting black gram crops with me. The accused persons also assaulted me. I sustained injury on my chest and hands. The accused persons left the place of occurrence after making assault on us. Moinal Haq died on the spot on the day of incident. Altogether, 10 persons assaulted us. Omnibus, my lord, petty omnibus, my lord. Thereafter, nothing of much importance thereafter, my lord. Now I come to the, my lord, with all respect, my lord, medical evidence that occurred at 101, my lord. This is doctor who examined PW9, my lord. His 9A that occurs at 101, my lord. Page 101, my lord. Lordship.
Yes.
Here, my lord, let me again place it, my lord. The occurrence took place, my lord, with all respect, my lord, on 2012-2006, my lord. 2012-2006. PW9, the NGO, did not name anybody in his statement. And, my lord, on occurrence took place, again, I'm repeating, my lord, putting emphasis, my lord, 2012-2006. And he was medically examined as per the doctor's evidence, my lord, 101, on oath, on 28-12-2006.
Yes.
My lord?
Yes, please
On 28-12-2006, I was at Dhuburi Civil Hospital as SDM and health officer. On that day, I examined Joinal, PW9, stake, and found as follows: 5 injuries, my lord. That occurs at 101, my lord. Thereafter, his opinion, my lord, something could not be read, possibly could not be translated. The injuries were 0 to 24 hours old, caused by, this cervixes would be caused possibly, my lord, caused by sharp object. Lordship has found, my lord. Second line of 102 page, my lord. And then I come to the medical report exactly, my lord. That has also been annexed, my lord. Occurrence took place on 2012-2006. Date of examination is 28-12-2006. 8 days subsequently, and with all respect and folded hands, my lord, doctor opined that the injuries were, with all respect, my lord, 24 hours old, meaning thereby.
Ms. Begum, where is the evidence against the other appellants?
No.
Except Abdul Hai.
Abdul Hai, there is, I have gone through, I have not found
no
that
other
nobody has.
Correct. And we'll allow 9 of them to go on bail. We'll see what happens.
Lordship.
These are all omnibus evidence,
Lord-
accused persons.
Lordship, but Abdul Hai is the main lordship. He.
All right, heard Mr. B.K. Mahajan, learned counsel appearing for the applicant, also heard Ms. A. Begum, learned APP Assam appearing for the state. The 10 applicants herein were convicted under section 302 of the IPC, read with section 149 of IPC, for committing the murder of one, what is his name? Moinal.
Moinal, my lord.
Moinal Haq, and sentenced to under imprisonment for life, and also to pay fine of rupees fine of rupees 5,000 each in default, to suffer simple imprisonment for six months, full stop. All these appellants stroke applicants were also convicted under section 326/149 IPC and sentenced to undergo rigorous imprisonment for 2 years, and also to pay fine of rupees 2,000 for causing grievous injury. Grievous injury.
My lord, my lord.
To the victim.
3 years, my lord.
Victims. So rigorous imprisonment for 3 years. 2,000 rupees is a fine in default, to suffer RI for 2 months. Stop. Since then, it would be by the judgment and order dated so and so. By the judgment and order dated
2/3/24, my lord.
2/3/2024, passed by the learned Additional Sessions Judge Dhubri in connection with Sessions Case number 38 of 2009. Then these appellants are so and so, so and so. Then all these appellants were also convicted under so and so for committing grievous injury, for causing grievous injury to the victims. Full stop. Since then, they are in jail. By filing the present IA, the appellants as applicants have approached this court seeking suspension of their jail sentence and for their release on bail. Full stop. By referring to the materials on record, Mr. Mahajan has argued that there is no evidence to convict any of the applicants in this case. So, however, even assuming that the evidence adduced by the prosecution witnesses are taken on the face value, even then, the key witnesses, namely PW's 2, 3, and the injured witness PW9
My lord.
have implicated only the applicant number 1, namely Abdul Hai, in this case,
My lord.
inasmuch as none of the witnesses have implicated any of the other accused persons, stroke applicants, stroke appellants in committing the offense. Full stop. Referring to the evidence on record, Mr. Mahajan submits that the evidence is omnibus in nature without giving specific particulars of involvement of the accused persons. Full stop. Moreover, the medical evidence is at variance with the ocular evidence,
My lord.
raising further suspicion as regards the involvement of all the applicants, stroke accused persons in the incident. Full stop. It is also the submission of Mr. Mahajan that even in the FIR, presence of none of the applicants, stroke appellants have been indicated, thus raising a further question mark on the prosecution story. Circumstances, submits Mr. Mahajan, the applicants, stroke appellants are entitled to be released on bail during the pendency of the connected appeal. Full stop. State has filed objection opposing the prayer made in the bail petition. However, Ms. A. Begum, learned APP Assam, has argued noted. However, Ms. Begum, learned APP Assam, has submitted in her usual fairness that From the evidence on record, it is seen that save and accept the applicant number one, Abdul Hai Mandal, none of the other applicants have been directly implicated by the accused person in commission of any overt or covert act in this case. Full stop. We have considered the submissions made by learned counsel for both the sides and have also gone through the materials placed before us. Having considered the materials available on record, we are also of the prima facie opinion that the evidence brought on record by the prosecution implicates Abdul Hai Mandal in commission of the offense. What about accused number two?
Two,
We have
my lord,
mentioned about accused number two.
Number 2 is mentioned in the FIR, not in the evidence.
mentioned in the FIR, my lord, nowhere in evidence, my lord.
But his name is in the FIR.
Huh?
FIR he is mentioned.
Applicant number one, then he give his name, Abdul Hai Mandal. Insofar as the applicant number two, what is his name? Applicant number two?
Baten Ali, my lord.
Baten Ali. And applicant number five,
Afzal Haq.
Afzal Haq.
Afzal Haq are concerned. Although their names were mentioned in the FIR, yet it appears that none of the witnesses have directly implicated them during while adducing evidence before the court. Under the circumstances, we are of the view that the applicants have made out a strong prima facie case for release on bail, save and accept the applicant number one. We are of the prima facie opinion that save and accept the applicant number one, Abdul Hai Mandal. The other 9 applicants have made out a strong prima facie case for their release on bail during the pendency of the appeal. First of, we therefore direct that the applicant numbers 2 to 10, namely so-and-so, so-and-so, and so-and-so, be released on bail on furnishing a bond of rupees 30,000 each to the satisfaction of the learned additional sessions judge Dhubri. With the further condition that the 9 applicants released on bail shall not leave the jurisdiction of the officer in charge of the police station without his prior, will not leave the jurisdiction of the learned additional session judge Dhubri without prior written permission, and shall appear before the court below as and when directed by the learned additional session judge Dhubri. Full stop. The learned additional session judge Dhubri shall also be at liberty to impose any other additional condition for release of the 9 applicants on bail. Full stop. Consequently, the jail sentence of the 9 applicants noted above herein shall remain suspended until further orders. However, the bail prayer made by Abdul Hai Mandal is hereby rejected.
Highly obliged. Highly obliged, my lord. Okay.
May it please your lordship. Lordship, in this regard, the IA lordship on the previous occasion, lordship had heard the senior counsel, Mr. A.M. Bora at length. And lordship, today it was fixed, my respected senior friend, she might submit as to what specific material is there on evidence with regard to the applicant Baneshwar Subedar, my lord.
I'll just take 1 minute of your lordship.
Where is Mr. Bora?
Lordship, he could not be present today, my lord, in the court today. If your lordship permits, I'll conduct the matter.
You can, but
His contention of my learned senior friend,
but once we hear, we'll pass an order. So later on, after she submits, don't ask for time. That's what we're saying. Yes.
The PW7, who is the eyewitness, according to the prosecution, is not an eyewitness. For the first time, he gave his evidence before the trial court, and it was not stated before the IO, my lord. He made improvement in the code below. Lordship, may I take your lordship to page para 21, page 66 of the IA.
Yes.
During investigation, the statements of both PW7 and PW8 were recorded under 164 CRPC. Both of them confirmed the same, and the statements were exhibited at Exhibit 6 and 7 respectively. Perusal of the previous statements recorded under 164 CRPC go to show that both of them have reiterated in court in particular material particulars what they stated before the magistrate. Hence, their deposition court find corroboration from their previous statement also. So, Lordship, the contention made by my learned senior friend. Standing
Just a minute, you're reading for page 21.
Page 21.
Uh,
That before the IO, he did not state whatever he stated before the
This is the
court.
testimony of PW4.
7 and 8. Who have
Page 21 is.
page 66, my lord, para 21.
Page 66.
Lordship. So in his 164 statement, that the PW7, who is the eyewitness to the occurrence, my lord, and PW8, who is also an eyewitness to a certain part, my lord, they have stated before the IO as well as before before the magistrate who recorded 164 statement, your lordship, which is the previous statement, lordship. So, lordship, may I today also I make this prayer, my lord. Let the records come, enter be peruse, my lord. Then your lordship, whatever lordship passes, your lordship may pass, my lord. Because in his 164 statement, that cannot be discarded, your lordship, the face of it, my lord. They have stated whatever they have stated before the court, my lord. And there is no improvement to that effect. And whatever they have stated before the court, lordship, tallies the medical evidence as regards injury part.
No, just a minute. The applicant's case was that there is no evidence against one of the applicants, who is the father.
Manesar.
Manesar.
Manesar Subedar.
Yes.
As the IO has.
Just a minute.
Yes.
There is only one witness who has mentioned about Banesar in his testimony.
PW7.
PW7.
Which is for the first time before the court, according to them.
According to them.
Yes.
But
According
you are
to the
saying-
prosecution, which is recorded by the learned court below, there is 164 statement
Okay.
made by the eyewitness.
Where is the 164 statement?
That is, the records will reveal, they have not,
Records have,
they have not come.
where is the 164 statement of PW7?
Lordship, 164 statement I have obtained, my lord. However, my lord, if she's my learned senior friend has finished, my lord, then I might be allowed to reply, my lord.
On that small point, your lordship made the query. Lordship, since the IO has not supported the case of the prosecution, he is entitled for lordship bail, man. But my submission is that his previous statement he has stated before the court also. And there is GD entry to that effect prior to lodging of the FIR.
So according to you, PW7 has stated.
Yes,
in
my lord.
164
Yes,
About the involvement.
yes, lordship,
Banesar.
my lord,
So it is not a case that the evidence of PW7 is doubtful.
my lord. Lordship,
That's your argument.
my lord.
Anything else?
Lordship, and there are two parts of the two sets of evidences. One incident is taken place in the market, wherein there's a slapping of that the accused person slapped the victim, and thereafter, after a period of time, after a certain period, your lordship, the PW7 heard the accused person, Banesar, asking his wife to lordship give the weapon of offense, my lord, lathi, and then thereafter lathi and dao. Then, your lordship, there was shouting made by another accused person who is the wife of Banesar. She also shouted that he will be like his dead body will be found, and she was shouting. And then thereafter, one of the witness, the mother of PW7, he asked PW7 to go and visit, like to see the whereabouts, my lord. Then he saw the accused person at the place of occurrence. And this is not a case of 149. This is a case of under offense under 34, 30234. And when he made previous statement before the court, your lordship, that your lordship will have to take into account. My respectful submission is there.
May it please your lordship. Lordship, going by what my learned significant has submitted, my lord, PW7's, my lord, deposition, I'll draw your lordship's attention to page number 33, 32, it starts, my lord. that I just came out of fifth line, my lord. Fifth line at page number 32 of the IA. I just came out of my after having dinner. I saw my neighbor Baneshwar Subedar was loudly asking his wife Basanti Subedar to give a lathi and a dao. I saw she handed over a dao and a lathi to her husband Baneshwar Subedar. Then from the last line, my lord, that is one of the statement where the name is whispered, my lord. And the next is, my lord, I saw Deepak Subedar was holding my father and Ajit Subedar was assaulting him with a rod on the right side of the face near the eye. Baneshwar Subedar was standing nearby. Baneshwar Subedar, then subsequently, my lord, 3 lines that he witnessed the occurrence from the focus of headlight of scooty. Having seen the occurrence, I raised halla and shouted, they assaulted my father. Then Deepak Subedar, Ajit Subedar fled away by motorcycle towards Dokhinpat Sariali. Baneshwar Subedar entered toward the backside of a house of a person nearby the place of occurrence. So this is the only person, my lord, these are the only 2 avert page, that too no role. Even though going by, my lord, that this is for the first time in court, even if we assume that the material is admissible, my lord, there is absolutely no role attributed that he has participated, my lord. And he has said that he has clearly seen everything in the light of his headlight. Maybe Deepak Subedar and Ajit Subedar he has seen. So it's not that he might not have seen, he has seen. And despite that, my lord, in his statement, there is no avertment that the applicant before your lordship had dealt with any blow. Then, my lord, with regard to this, my lord, the witness was duly confronted, my lord. And thereafter, my lord, the IO has confirmed, my lord, that he has not stated in his previous statement before the IO. For this, my lord, the IO's evidence starts at page number 40, my lord, of the interlocutory application. Page number 40, the relevant portion is at page number 44. That is the inner 5th page of the IO's deposition. May I read, my lord? PW7 in his previous statement did not state that he saw Deepak Subedar was holding his father, Ajit Subedar was assaulting, and Baneshwar Subedar was standing there. That was not before the IO. Nextly, my lord, PW7 also did not state before me in his previous statement that Ajit Subedar assaulted his father with iron rod. And then, my lord, PW7 also, that is the one paragraph, leaving one paragraph, PW7 also did not state before me in his previous statement that Baneshwar Subedar was loudly asking his wife to give him a lathi and dao, and he saw him, Baneshwar, going in a motorcycle of another person taking a lathi and a dao. So probably the circumstance which is attempted to be brought, my lord, his deposition in my most humble submission is demolished, my lord, because the 161 statement which is recorded immediately after the incident or lodging of the FIR, my lord, those were not there, my lord. And this is the only thing, my lord, that my learned senior friend also has submitted fairly, my lord. Other witnesses, my lord, PW 2 and 3, who also allegedly have seen parts of the incident, my lord, one of them does not speak about any physical assault upon the deceased, and one of them says that one of the other appellants has given one slap. That is the entire totality of the, my lord, evidence on record. And this, my lord, afterthought. And
Where is the 164 statement?
164 statement, my lord, was recorded 2 months after the incident, my lord. That I could get a copy, my lord. Here, my lord, he has stated that the applicant has asked for a lathi. There's no whisper of dao. But in the court, while he deposes, there is a mention of dao and lathi. On the second page, lordship should find it.
Yes, so hmm. So in the 164, it says only about Lathi, not about Dao. There's some variance.
But your lordship, regarding the presence of the accused person,
Presence is vital,
presence,
not-
it's a case under 34, my lord, not 149. Specific awarded may not be required.
All right.
My submission be recorded.
Yes. Heard Mr. Your name, please?
DK Boyddo, my lord.
DK Woodall, and counsel appearing for the applicant. Also heard Ms. B. Bhuya, learned senior advocate, and additional PP Assam appearing for the state. Full stop. By the judgment and order dated 19/8/2024, passed by the learned additional district and session judge number 2, Nagaon, Assam, in connection with sessions bracket T1 bracket close case number 48/2017. The present applicant, along with two other accused persons, were convicted under sections 341/302/34 IPC for committing the murder of
One Durga Saikia. my
Acha,
lord.
all three are applicants. The three applicants.
My lord, only one
He's
applicant, my
paying
lord.
for only one.
Acha,
Vanessa.
along with
Three appellants, one applicant.
three accused persons, two accused persons, namely Deepak Subedar and Ajit Subedar, were convicted under sections 341/302/34 of IPC for committing the murder of
Durga Saikia.
Three accused persons.
Three convicted, my lord. Vanessor,
who is
Deepak,
the
and
victim?
Ajit.
I'm asking the name of the victim.
Durga
Durga
Saikia.
Saikia.
Durga.
Durga Saikia.
And each of them were sentenced to undergo rigorous imprisonment for life for committing the offense under section 302/34 IPC and to pay fine of rupees 10,000, in default, to undergo simple imprisonment for 3 months, and what about offense under 341? What is the imprisonment?
Lordship undergo simple imprisonment for 1 month with a
And
fine
to
of rupees
undergo
500.
Simple imprisonment for a period of 1 month and to pay rupees 500, in default, to undergo simple imprisonment for 7 days for committing the offense under section 341 of the IPC. All the accused persons, all the accused persons who were convicted by the learned additional sessions judge number 2, Nagaon, including the present applicant, have preferred criminal appeal number 345/2024, which is pending disposal before this court. Stop. The appellants are in jail, full stop. Therefore, the applicant, the sole applicant herein, namely, therefore, one of the appellants, that is Vanessa Subedar, has approached this court as sole applicant by filing the instant application under section 430 of the Bharatiya Nagarik Suraksha Samhita with a prayer to suspend his jail sentence, so to release him on bail during the pendency of the connected appeal. Stop. The state has filed objection opposing the prayer made in the IA. Full stop. By referring to the materials available on record, Mr. Boyddo has argued that even except the PW7, none of the witnesses have implicated the present applicant in any manner. Full stop. Even if the evidence of PW7 is taken on the face value, even then, submits Mr. Boyddo, he did not, this witness did not implicate the applicant while recording his statement before the IO, and even while recording his statement under section 164 CRPC before the court nearly after 2 months of the date of occurrence. PW7 has merely mentioned that the applicant had asked for a lathi and not any sharp weapon which was used in the incident. Full stop. Under such circumstances, Mr. Bodo submits that there is no good ground to sustain the conviction of the applicant under section 302/34 IPC. Therefore, his client deserves to be released on bail during the pendency of the appeal. Opposing the said prayer is B. Bhuya, learned at APP Assam, has strenuously argued that the PW7 who is an eyewitness to the occurrence, has clearly implicated the applicant. That apart, this witness has also implicated the applicant while recording his statement under section 164 CRPC. Full stop. He was present. The fact that the applicant was present in the place of occurrence has gone unrebutted. Full stop. Under the circumstances, the applicant is equally guilty and stands under the circumstances, submits Ms. Bhuya. The applicant is equally guilty and stands on equal footing with the other two appellants accused who have been convicted by the learned court below. Full stop. In view of the above, the learned APP has prayed for dismissal of the bail application. Full stop. We have considered anything else? We have considered the arguments.
Medical opinion, the cause of death due to shock and hemorrhage, a result of major head injury, a fracture of skull.
The learned APP has further invited the attention of this court to the medical opinion, which indicates that the cause of death is shock and injury in the head, on the head, causing fracture of skull, leading to the death. We have considered the submissions made at the bar and have also gone through the material available on record. There is no denial of the fact that seven except the PW7, none of the other witnesses have taken the name of the applicant or have stated about his presence in the place of occurrence. The question is the evidence of PW7 sufficient to establish the guilt of the applicant beyond reasonable doubt? We are of the view that such a conclusion cannot be drawn readily without a deeper hearing of the appeal. This we say so for the following reasons. Firstly, the PW7 has merely stated that the applicant was present in the place of occurrence and had asked his wife to hand over a lathi and a dao. Full stop. In his statement recorded under section 164 CRPC, this witness has only stated about the applicant asking for a lathi and not a dao. Full stop. Moreover, the PW7 has not made any such statement before the IO, which fact has been proved from the during the cross-examination of the IO, who was examined as
PW9.
PW9. Full stop. Viewed from the perspective of materials available on record, we are of the view that there is some doubt as to whether the applicant herein can be said to have played any overt or covert role leading to the death of the deceased. Full stop. Such a doubt, however, does not arise with regard to the other two accused persons against whom sufficient and cogent evidence appear to be present on record. Under the circumstances, we are unable to agree with the submission of the learned APP that the applicant herein stands on equal footing with regard to the other two accused stroke appellants who have been convicted in this case. Full stop. For the foregoing reasons, we are of the view that the applicant has made out a strong prima facie case for suspension of his jail sentence, and also to release him on bail. Full stop. We accordingly direct that the applicant, namely Baneswar Subedar, be released on bail on furnishing a bond of rupees 30,000 and one surety of like amount to the satisfaction of the learned additional district and session judge number 2, Nagaon. In addition to the above, the learned additional district and session judge Nagaon shall also be entitled to impose any other additional condition for release of the applicant on bail. Full stop. Consequently, the jail sentence of the applicant, namely so and so, shall remain suspended until further orders. Highest stands disposed of.
Observation made the instant application may not affect the merit of the case.
We however make it clear that the observations made herein above are tentative in nature and shall not have any bearing during final hearing of the pending appeal. The highest stands disposed of.
The records we called for in the main appeal,
Main appeal.
already called for, but it hasn't
On
come.
the main appeal, you write so and so for the appellant, so and so for the state. Office to issue reminder for the LCR so as to expedite hearing of the appeal. Yes, Mr. Manan, what is your?
Next item.
Next item.
You're ready for hearing?
Yes, yes.
How many
It will not
witnesses?
take very long, very short matter.
Alright.
We can finish up, you know, I've already, it is maybe it's a proxy matter, but it's not a very long, it's a short matter.
9 witnesses, but for the victim,
No, they have not appeared earlier also. And it has been here for a long time.
Is it necessary to engage a legal aid counsel for the victim?
yes, no, the POXO matter.
His name is shown, PK Muni's name has been shown, but yes, he did not appear. On the last occasion, a learned friend also prayed for time to go through, and so it was fixed
Yes,
today.
my lord.
It was fixed today. It's a very short matter, it's not very long matter, in fact.
No, but without
Yes.
hearing the,
Yeah, but
will not
PK
pass a
Muni's
judgment.
name is shown, but he's not available.
So can you find out where he is?
Let,
Huh? If he comes, we'll hear him. Otherwise, we'll
Yeah.
delete his name. And we have to hear someone for the.
yes, yes, absolutely.
That is,
I'll try to
if PK Moran
contact.
is ready
yes.
and comes, we'll
Yes.
hear it.
Yes, yes.
If he is not available or he doesn't want to do the hearing,
Then
we'll
it's a different matter.
then it's a different, because the victim has to be heard.
Yes, yes,
Victim's version has to be heard.
yes.